right. Welcome to Ganja Law 101, Episode 3. Um, this is going to be, we did a deep dive into the international treaties, and the Commission on Narcotic Drugs met for their 66th session in Vienna, Austria on March 13 to 17. So I'm going to talk about that, and because they're going to talk about these treaties, so it just goes right back to that, showing you how that's still being talked about. And then the International Narcotics Control Board report, which I read a summary from. This is a more detailed report from that same event. And then I'm going to talk about a court case that involves exemptions. I talked a little bit about that. 21 USC 822D, and there's a court case from federal district court on that. And then we've got some bills that have been filed that would add raw cannabis to our medical cannabidiol program here in Iowa. So that covers the full range, international, federal, and state, showing how these things are all intertwined and so forth. So without further ado, let me jump in here. And so here we got the United Nations Commission on Narcotic Drugs, and they met in Vienna, Austria on March 13 to 17. And that's all I'm going to say about that. Then I'm going to flip to the International Narcotics Control Board. And down here under their annual report for 2022, they have a thematic chapter on the analysis of the trend to legalize the non-medical use of cannabis. And that's what I'm going to talk about here. So in that report, they have a section on cannabis, and it says analysis of the trend to legalize the non-medical use of cannabis. Well, on page 9 of that report, it says that these treaties contain provisions that safeguard the state parties' domestic constitution and legislation. And the reason they're mentioning that is because they don't think that these treaties allow the state parties to authorize the non-medical use of cannabis. Even though, if you read that, it clearly says they do. So, what are these guys actually talking about? So, another thing is that if you'll notice, it's the International Narcotics Control Board. Let me go back to that. International Narcotics Control Board. That is not that's not an enforcement body. That is not a judicial body. All that is an advisory board. Boards don't have that kind of power. We have a medical cannabidiol board here in Iowa, and they make recommendations, but they don't get to decide anything. Other people listen to them and may or may not do something based on their advice, and they're very influential, which I'm sure this board is too, but keep that in mind. It's just a board. So anyway, going back to that, and then I read, so on page 10, they said, even if a party in application of a safeguard clause is precluded by its constitution from the obligation to carry out measures under Article 36, paragraph 1 or 2 of the 1961 Convention, or Article 3, paragraph 2 of the 1988 Convention. Well, I'll show you what those are. Those are the exemption clauses. And it's like they're saying that countries can't have exemptions, and then they point out the language in the treaty that says, oh yes, they can. Like, what? These guys are, I mean, it's just a board, so they have an opinion here, but I don't agree with it, and I don't think anybody else has to, and it's not supported by anything. But anyway, let me go back to that. What I wanted to do is that I have a page here where I've kind of highlighted these treaties, and let's see. I presented something to the city of Des Moines here last year. Was it last year? Oh no, it's been a while. But anyway, so here's what they're talking about. This is a single convention, and here's Article 36, Section 1 and Section 2. And it just says that the treaty is subject to the constitutional limitations of the signatory party. And then Article 2 says subject to the constitutional limitations, its legal system, and domestic law. Well, here in Iowa, this medical cannabis program that we have is a domestic law for sure. And it's constitutional. It hasn't been challenged as being unconstitutional. The federal government certainly hasn't challenged it, and the federal government signed the treaty, not the state. So the federal government would have to say the state doesn't have the right to do this, to invoke the to do what the Narcotics Control Board wants, to say that this isn't legitimate. Okay, the United States government apparently thinks it is legitimate. So, and then the other treaty, here's the one they were talking about on trafficking, Article 3, Section 1, and that one just says constitutional principles, but I just described how domestic law is part of constitutional law, and so it really means that there's nothing different about the language they chose there. It's just different ways of saying the same thing. So that covers that. So I wanted to go back to that. I mentioned that in the last episode, that this board had complained about the United States being out of compliance with the treaties. Well, they may think the United States is out of compliance with the treaties, but they have no enforcement authority, and they're wrong. So when you put those two things together, it's like, they're probably a little miffed that they've had to go and put up with this treaty all these years that the United States shoved down their throats. They're probably saying, you guys are hypocrites, like, which is true. Yep, that's true. The United States has not been playing the game very well, but nevertheless, we're not out of compliance with the treaty. Okay, so the next thing I wanted to go to was, I had talked about the federal exemption, that the administrator has the authority to waive the registration requirements for manufacturers, distributors, and dispensers. And I mentioned that there were 5 peyote distributors in Texas who are licensed by the state of Texas and by the federal government, the DEA. They're registered, so they have state and federal license to distribute a controlled substance in Schedule 1 that is being used not for medical or scientific purposes. So maybe I should go back to these treaties just for a second and hit that. So what they're talking about is that we're out of compliance with Article 4, Section D of the single convention. So let me go to that. So I'll just go to Article 36 and then scroll backward here. So here's Article 36, and then if you scroll up here to Article 4, how many pages do I gotta go? Let's see. Article 20, Article 7, getting close. Here we go. Article 4, Section C. That's the one. Subject to the provisions of this convention to limit exclusively to medical and scientific purposes for the production, manufacture, export, import, distribution, trade-in, use, and possession of drugs. Well, the United States carved out a peyote exemption for religious use when they signed these treaties, and so, like, right there, that doesn't, like, the international treaty was signed with a exemption for religious use of peyote, and it's not medical or scientific. So right there, they're complaining that the United States is not in compliance with this, and the United States has never been in compliance with this and never been challenged before. So they're cherry picking here. They're picking on marijuana and going, oh, peyote, we'll just ignore that. We don't even know about that. Sorry, that's they're not even sorry. They're just acting like they can't read, or you got to remember, the peyote exemption was created in 1965, and it was in the treaty in 1971. And so that's a long time ago, and marijuana wasn't even under discussion. So they have just forgotten that there are exceptions to this language, and that's what's going on. They just don't realize that they're wrong. They are wrong. there are exceptions to Article 4, Section C. Clearly there are. So anyway, and then the reason I bring that up is because this federal court case is dealing with that. So this is from the U.S. District Court from the District of Columbia last Friday, 2 days ago. This decision was made. Come on. Okay, so here it is. Ayahuasca Church. Well, what a coincidence. That just happens to be in Des Moines, Iowa. That's where I am right now. So this church applied for a IRS tax exemption, and the court denied the appeal. Well, the IRS denied the exemption, and the court denied the appeal. And the reason why is because they have an application for DEA registration pending, and they haven't got it yet. So asking the IRS for an exemption when they're still in violation of federal drug law, the IRS just said you have to wait and get a ruling from the DEA. You have to be legal to do what it is you're proposing to do before you can get an IRS tax exemption, income tax exemption, which makes perfect sense. They're out of order. And they don't have any Iowa registration whatsoever. They don't have the right to use controlled substances in Iowa, and they've completely they don't have any action pending to get legal authority to operate in the state of Iowa. So they are really missing some. They certainly don't understand what they're doing. So on page 4 of that decision, it says the plaintiffs had not sought relief in the courts or received the exemption to the CSA from the DEA. They applied for the DEA exemption in 2019, and so what the court is saying is like they could have appealed that by now, or they could have gotten an answer from the DEA, and they haven't done anything. And if they want to file a case in federal court, they need to complain about the DEA taking so long to rule on their petition, and that would be their proper place to complain. And then on page 11, it mentions what I was talking about. See, the Controlled Substances Act authorizes the Attorney General to create exemptions from the prohibitions on handling controlled substances. See 21 U.S.C. 822D, which is what I talked about last week. An individual seeking a CSA exemption must file a written request to the DEA to obtain exemption, as the plaintiff has done here, under 21 CFR 1307.03. Well, the issue here is that 21 U.S.C. 822D and 21 CFR 1307.03 have been in the Controlled Substances Act long before the Religious Freedom Restoration Act was enacted in 1993. This stuff is from back in 1970. So there isn't anything about this that even has anything to do with a religious claim. These are exemptions that have always existed. And again, the treaty, there's never been any suggestion from the International Narcotics Control Board that the Attorney General cannot use this authority to create exemptions. And so, they are so out of order. But anyway, the United States hasn't created an exemption for state cannabis programs, and so the International Narcotics Control Board can complain because the United States hasn't even attempted to say that those are exemptions. So that's the problem. If the United States were to claim that those are exemptions, they would have to somehow grant them an exemption first under federal drug law, and then tell the International Narcotics Control Board that they have created such an exemption, and then invoke the treaty language for the exemptions. So the United States is totally out of order too. Don't get me wrong here. I'm not blaming the International Narcotics Control Board can clearly see the United States has no idea what it's doing, and they're taking full advantage of it. And you and I pay for that because we're not getting effective representation. We're not getting good government here. Okay, so then finally going back to Iowa here, we got a couple bills that would add raw cannabis to our program. And there was a bill in the Senate to do the same thing that was filed January 31st, and it got killed. And I'll show you why for. Well, because there was a hearing on February 28th on that bill, And the day before the hearing, well, not the day before, actually, on February 10th, the board held an emergency meeting and said they didn't agree with the Senate Study Bill 1113. And so that hit the newspaper the day before the hearing. The board released its final report on the raw cannabis on February 27th. And then on February 28th, a subcommittee hearing was held, and there weren't enough votes for the bill, and the chair of the committee withdrew the bill. So now it's back. It has got new life here, and it has come back and filed Friday as House Study Bill 242. And so now it won't hit the newspaper again. There won't be a big scandal because that's already happened, and it won't happen again. The board doesn't agree with it, and nobody has to listen to the board, but the board does have the right to express an opinion, and they were unhappy with the way things were going. There was other things involved. They said the manufacturer was too aggressive in its marketing and was trying to portray cannabis as a lifestyle choice rather than a medicine, and that we only have medical use in Iowa. We don't have, adult use cannabis, and so the manufacturer was taking liberty and stretching things too far by aggressively marketing this as a lifestyle choice. So that's back again, and there you have the explanation of why that's back again and why I'm talking about it, because it was just filed on Friday. So now that will open up a whole another round of discussions on cannabis, and adding raw cannabis to our program is a huge change, and it won't go silently. It will be talked about quite a bit. So that's what I'm looking forward to, is more opportunity to talk about cannabis. And then I just might mention that I was mentioned in the Capitol Dispatch on February 26th as well, and it said I am trying to get the right to use cannabis as a religious sacrament in Iowa, which is why I mentioned that other group is not doing that. I am doing that. So it's like, wouldn't you want a state exemption first? These peyote exemptions all started at the state level back in the 50s and 60s, and they got exemptions at the state level. And by the time that the federal government got around to adding peyote to the Controlled Substances Act, the federal government added a religious exemption to complement the state exemptions for religious use of peyote. And so the same thing here. We have 5 marijuana dispensaries in Iowa, and they're all registered by the state. Peyote, there are 5 distributors in Texas. They're all registered by the state. But the peyote distributors have federal registrations, and the Iowa distributors do not. That's the problem. They need to have federal registration. So that's it for episode 3. I think that covers a whole lot. That brings you up to speed, shows you how current events are related to the history that I showed in episode 1 and 2. And so there you have it. I'll just wrap it up with that. Thanks for watching. See you next time.